Want to call to order the third meeting for 2025 of the Rhode Island Ethics Commission. I'll note for the record that we have a quorum of 7 members present. And the first item on the agenda is a motion to approve the minutes of the open session held on January 28th, 2025. Is there a motion? Motion by Commissioner Luzzi. Is there a second? Second by Commissioner Centerini. Roll call vote. Any discussion? Roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Dr. Brown is not here. Commissioner Centerini.
Aye.
Commissioner Peterson.
Abstain?
Mr. Ravidu.
Abstain.
Commissioner Ritchie.
Aye.
The chair votes aye. The next item on the agenda is the director's report.
Good morning, everyone. I'm just going to note that we are live streaming our open session today. As we always do, the agenda is on our website for the public to view and download the meeting materials for today, which includes all of the draft advisory opinions and the matters relating to the petition for rulemaking are all also available on our website. The live stream will continue to run through open session. At one point, we will go into executive session very briefly, probably just for 1 or 2 minutes in order to approve some minutes. And the live stream will stop at that point, and then we'll come back into open session. The live stream will come back in again, and we'll finish the meeting at that point. So then to move on to talk about complaints and investigations, we have 3 complaints still pending with the Ethics Commission. Just to give you a quick update on those. The James Thorson complaint, as you know, discovery is ongoing. It's out of state discovery. You have authorized a subpoena for a couple of out-of-state witnesses. I'm informed that that your subpoena was brought to the Superior Court, where the Superior Court then issued its own subpoena, which was then domesticated in Philadelphia in the Court of Common Pleas. The Philadelphia Court of Common Pleas has issued a subpoena. That subpoena should have been served last week on the witnesses, and so now we wait to see if the deposition will take place, and if it does, it'll probably be in March. So I'll keep you up to date on that. As soon as the discovery is completed, we'll schedule an adjudication. Michael Colasanti.
Could I interrupt that? Do we expect any kind of pre-adjudication motion practice?
I think you should always expect some pre-adjudication motion practice, whether it's a motion to dismiss or something like that. But sometimes that can just be folded into the adjudication proper. So I don't know. I don't have the information about any particular motions that might be filed, but frequently we do see a little bit.
I only ask because I'm wondering whether, as it comes forward, we're going to want to have a meeting about it on motions and then a meeting on adjudication.
We may, depending upon what gets filed.
Okay.
So then, Michael Colasanti complaint number 2023-10. This is one that's ready for adjudication. We're in the process of scheduling it. But at the agreement of all of the parties, a decision was made for us all to sit down one last time and conference this case. So we're going to do that this week. And depending upon how that goes, we'll either be before you for some type of informal resolution or for an adjudication. And again, we're probably looking at late March at this point, conceivably. Finally, there's one last complaint pending, in Heidi Weston Rogers, and that's still under nothing coming before you on that. Lastly, there is still, I guess, technically the open case in Anastasia Williams. You've dismissed that, and we're waiting on the decision in order. That's going to issue today. So after today's meeting, that final decision will issue. Any questions about anything? Just moving on to advisory opinions. We have 8 pending advisory opinions that we're actively working on. That includes the 3 on today's agenda. So after today, assuming these are all taken care of, there'll be 5 for today. For a day or two until more come in, and they are coming in every day. APRA requests, we only had 2 since the last meeting, but they were both pretty substantial. Both were completed in 1 business day. One related to wanting copies of some historical advisory opinions, including all the way back to 1989, 1994, but we have those and we provided them, I think on the same day that they were asked for. And the other related to someone wanted all of the recusal statements that were filed by a particular town council for the last 6 years. And fortunately, we just completed the recusal module where we now have case management for recusals, and we were easily able to access all of those and provide them the same business day that they were asked. So, doing really well on it.
So I have a question for you. When you get an APRA request, if you think that the APRA request is inappropriate, is there a time where you're gonna have to bring that to us? Or is that something that's done administratively?
We have always handled APRA administratively. They're set procedures, and we provide these procedures to, letter to the person asking. So, for instance, someone asks for certain documents. The first response is either to say granted, or we call them and say, let's talk about it and narrow it down. Or maybe we might say there are no responsive documents, or we're not giving you these because they're investigatory records. Right in that letter, we also let them know what the appeal process is. And the first level of appeal is under APRA, they can appeal to the executive director to reconsider that decision. To date, no one has, I don't think, ever appealed that decision. Then again, we grant, we're in favor of granting. We're not an agency that's looking to deny. So unless it's an investigative record, we almost always say yes. So I've never had anything where we've denied it, they've come to me, I've denied it again, and it was something that I needed to bring to the Ethics Commission.
Would that be the next step?
It actually wouldn't be. I think the next step would be to go to the Attorney General.
For them to go, they didn't like what you did.
Right. I probably, if something like that was going to happen, I would advise you. I mean, I'm not going to have us go before the Superior Court or the AG's office on an APRA complaint without you knowing. So I'm sure you do.
Thank you.
Regarding financial disclosure, I don't really have any updates other than, as you know, the deadline for that is April 5th, 2025. We haven't sent out the blue notice letters yet. You will receive those in March. So we get mid next month. You'll get, if you haven't filed already, you'll get a notice in the mail with all of your. Believe you me, I won't let any of you not file. You'll definitely know. Then finally, just some general office and administration matters. Our next meeting is March 4th, I believe. That's 3 weeks from now. I'm working on some information regarding the gift limits that we talked about. We were talking about whether to stick with the 25 or whether it's time to move from that. I want to get some materials to give to you to further that conversation and help inform you before we put it on the agenda. And I'm working on that. Get that. And the last thing I'll just mention is, you notice we have the monitor in the room today. Today is going to be the first time that the Ethics Commission has had remote participation in our meeting. We've had remote meetings before during COVID, of course. Those are no longer authorized. That's why all of you, the decision makers, have to be in the room. You're not allowed to remote into any of our meetings, but members of the public can remote in. And we have one of our petitioners today who's going to answer your questions and speak to you via remote participation. That's the first advisory opinion that's up today. And this is something that we'll also be able to use if we ever go into rulemaking and we would take public testimony. People will be able to come speak to you here in the room, and we'll also allow it by remote. Nice thing.
That might be of consequence of Dorsey.
Could be for remote witnesses, yes. That's all I have for director's report. Do you have any further questions?
Do you have any questions of the executive director? The next item on the agenda are the advisory opinions, and we're going to be taking Catherine McMahon first.
Ms. McMahon is the petitioner who's coming in remotely, so take me a moment to bring her into the meeting, and you should be able to see her on the screen. Ms. McMahon, we're about to bring you in and promote you to panelist. You'll just bear with me. It will ask you if you accept the promotion, and you'll just click OK when that comes.
I want a promotion.
Okay, you're in the meeting. Ms. McMahon, if you could, unmute at least your audio and preferably your audio and your video, if that's okay.
I think I found the unmute. Now I gotta find the where the. Oh, there it is.
Great, we can hear you now.
I'm not used to Zoom. All my meetings are usually in Microsoft Teams.
Well, you did great. You're here and we can hear you and see you, so thank you.
Welcome.
Hello.
You'll find the draft for this petitioner at tab B in your binders. Good morning, Ms. McMahon. Nice to see
Good
you.
morning.
A different version of the draft advisory opinion from Ms. McMahon that is before you today was presented at the last commission meeting on January 28th. At that time, the commission had questions of the petitioner that I was unable to answer on her behalf. Immediately after the last meeting, I contacted Ms. McMahon, who provided the information requested, which I then incorporated into this new draft. Ms. McMahon, who lives in Narragansett, works remotely from home, and for whom traveling here today would have been difficult given her current work duties, has indeed joined us via Zoom and will be available to answer any additional questions that might arise and or to address the commission with questions or comments of her own. The petitioner is employed by the Rhode Island Department of Administration as the Assistant Director of Financial and Contract Management. She holds a master's degree in business administration with concentrations in accounting and finance. She is currently assigned to the development of the new state financial system, which has a projected launch date of July 1st of 2025. Among her duties in that capacity, she serves as one of the lead contacts for the integration of the state's credit card program with Workday, which is a computer software company and state vendor, which provides the software that the state will use to develop new human resources and finance programs for use by all state employees. The state contracts with JP Morgan Chase for all credit card services. That contract was awarded by the state's Division of Purchases and has been in place for many years. The state is considering the use of additional features available through Chase's credit card program. Specifically, the state may elect to replace the physical credit cards currently used by state employees for out-of-state business travel and or small purchases with virtual credit cards. Ms. McMahon is one in a group of 4 people who will determine whether to recommend to the state's controller and possibly the director of administration whether the state's current contract with Chase should be extended to include the provision and use of virtual credit cards. Ultimately, the decision of whether to do so will be made by the controller and or the director of administration and will depend on whether Chase can successfully integrate with Workday. The petitioner states that the focus of her responsibility would be the integration of a virtual credit card system into the new state financial system, which is still in the development phase. The petitioner represents that there would be no change to the value of Chase's contract with the state as a result of replacing the physical credit cards with virtual ones. Petitioner further represents that there will be no cost to the state in the event that this change is implemented. She explains that the state will continue to earn a percentage of the credit card fees generated during use, regardless of whether physical or virtual cards are used to generate those fees. Ms. McMahon was one of 7 siblings who each inherited about 1,000 shares of Chase stock from their mom in 2010, At least one of her siblings has enhanced his Chase stock portfolio, but Ms. McMahon does not know, nor is she in a position to determine by how much. The petitioner is unsure of which of her other siblings, if any, have since purchased additional Chase stock shares and or sold or traded any of the shares that they inherited from their mother. Ms. McMahon informs that one of her siblings is now deceased, and Ms. McMahon is in no position to know or determine whether any of her deceased siblings' heirs or familial legatees own Chase stock. Ms. McMahon states that her shares are valued at $239 each, and that she receives a quarterly dividend of about $1,200 on her shares. The petitioner's reported holdings in Chase stock constitute approximately 0.000003624% of its outstanding shares, which exceed 2.8 billion. Ms. McMahon states that she has not engaged in the sale or lending of any of the Chase stock shares that she inherited in 2010, and that she has not otherwise engaged in the purchase or trading of Chase stock. The petitioner represents that a decision by the state to replace the physical credit cards used by state employees with virtual ones under the state's contract with Chase will not impact the value of Chase stock. She explains that Chase is an international company and that the potential changes being contemplated by the state would be minuscule in comparison to the size of the corporation. At issue here is whether the petitioner's proposed conduct would amount to her taking action in her official capacity that will directly financially impact her and her siblings who own Chase stock. Such a direct financial impact must be reasonably foreseeable. That is, the probability must be more than conceivable, but less than certain to occur. The three advisory opinions which issued in 2008, cited on pages 3 and 4 of the draft, are the basis on which this petitioner and JP Morgan Chase are not considered business associates. In advisory opinion 2008-53, the Ethics Commission opined that while it may be a fair presumption that most, if not all, shareholders of a privately held business are capable of influencing the business's financial objectives, this presumption would not accurately describe the relationship between a large publicly traded corporation and its average shareholders. The petitioner in advisory opinion 2008-53 was a member of the Tiverton Zoning Board of Review who had inquired about her ability to participate in discussions and voting on a petition for a land use variance brought by CVS. The petition related to allowable signage and the implementation of a drive-through pharmacy window at one of CVS's retail locations. That petitioner owned 450 shares of CVS common stock, so 0.000003125% of CVS's 1.44 billion outstanding shares. The Ethics Commission determined that it would be incorrect to assert that that petitioner was a business associate of CVS, as that term is defined in the Code of Ethics. Instead, the Ethics Commission's analysis turned on whether the market value of the petitioner's CVS stock, regardless of what it was, would likely be impacted by the decision of the zoning board. If so, then the Code of Ethics would require her to recuse. Using the same totality of the circumstances analysis employed by the Ethics Commission then to conclude that it was not reasonably foreseeable that the decision of the zoning board regarding the application by the CVS would not financially impact that petitioner. Here, the instant petitioner is a member of a small group of people who will meet to determine what recommendation to make to the state's controller, possibly the director of administration, regarding whether to extend the state's use of Chase services to include the issuance of virtual credit cards to state employees to replace the physical ones used now for out-of-state business travel and small purchases. The petitioner states there will be no change to the value of Chase's contract with the state as a result of implementing the switch. The petitioner owns 1,022 shares of Chase stock valued at $239 each. Again, her holdings constitute a minuscule percentage of Chase's outstanding shares, which total more than 2.8 billion. Ms. McMahon represents that she is not engaged in the sale or lending of any of the Chase shares that she inherited in 2010, nor has she otherwise engaged in the purchase or trading of Chase stock. She adds that a decision by the state to replace physical credit cards with virtual ones under the state's contract with Chase will not impact the value of Chase stock. Again, Chase is an international company. The potential changes being contemplated by the state would be minuscule in comparison to the size of that corporation. Under these circumstances, it is not reasonably foreseeable that Chase's share price will be impacted by the state's ultimate decision about whether to have Chase provide virtual credit cards to Rhode Island state employees in place of the physical ones they use now for the purposes identified. Additionally, it's similarly not reasonably foreseeable that any of the petitioner's family members would be directly financially impacted by the petitioner's proposed official activity. Accordingly, it is the opinion of staff that the petitioner is permitted by the Code of Ethics to participate in discussions and recommendations relating to the state's potential use of additional Chase services as described today and in the draft. I'm happy to answer any questions or, of course, to defer to Ms. McMahon.
Morning, Ms. McMahon.
Good morning.
You've heard Ms. Radish's presentation. Do you have any comments or questions?
No, it's pretty accurate. I mean, the stock, when I looked this morning, is actually increased even more. To, I think it's like $271 per share now. And we haven't done anything. And it's gone up over $100 in the past year, just because Chase is such a well-performing bank, and Jamie Dimon's every word is listened to by the economists all the time. So, but this delay in trying to get this opinion has caused a pause with any interaction with Chase on the integration that we need to get going, because our drop dead date is July 1 to go live with the new ERP.
Does anyone else have any questions of Ms. McMahon?
I do.
Mr. Ritchie?
Good morning, Mr. McMahon.
Good morning.
What is the amount of the contract the state has now with Chase, and what will it be when the implementation takes place?
I looked at what the purchase agreement is when I last met with Lynn a couple of weeks ago, and it states that there's no cost to the state, that I know we get rebates because I've seen them posted to people's accounts.
Can you
So
kindly what the contract amount is, please?
there is no dollar amount on it.
What is the state currently paying?
They're
Chase.
not paying.
They're not paying Chase?
They're not paying, and it specifically states within the purchase order that there will be no cost to the state. The weird doing a rebate, kind of, you can equivalent it to like how you have credit cards that do the mileage, give you the mileage points. Our credit card gives us cash, and then it's gone back and posted to all the various agencies based on the usage.
But you do currently have a contract with Chase, do you not?
There is a contract with Chase, and from what I was told, it's been extended for 2 more years.
And what's the amount of that contract, please?
There is no dollar amount.
Chase is doing this for the goodness.
It's a credit card. It's just like we get a refund from it. I'll go back and pull up the actual contract and send you all the attachments that I found in RIFANS, which is the state financial system. I don't recall the contract number off the top of my head, but I will send it to you.
It's not necessary. I don't know, my fellow commissioners feel, but that's okay. Except what you're saying.
Any more? Any other questions, Ms. McMahon? Any questions for Ms. Radishis? Is there a motion to approve and issue the advisory opinion as presented by the staff?
I'll second.
Motion by Commissioner Peterson, second by Commissioner Rapidu. Roll call vote, Commissioner Susie,
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rapidu,
Aye.
Commissioner Ritchie. The chair votes aye. Thank you, Ms. McMahon. We appreciate you being able to be here today.
Thank you.
The next item is Megan Gilbert.
Good morning, commissioners. This draft advisory opinion is under tab C in your binders. Ms. Gilbert is employed as a social care worker with the Rhode Island Department of Behavioral Health Care, Developmental Disabilities and Hospitals, or BHDDH. Currently, she is on full-time education leave from her position in order to pursue her master's degree in macro-level social work at Rhode Island College. The petitioner represents that she plans to return to her state position after the spring 2025 semester ends, which is in mid-April of this year. As part of her studies, she's completing an internship with the Economic Progress Institute. She describes the institute as a private nonprofit advocacy entity whose goal is to ensure the economic progress of all low and moderate income Rhode Islanders. The institute seeks to achieve its goal through research, analysis, advocacy, and education. The petitioner would like, as part of her internship, to serve as a lobbyist for the institute. The petitioner represents that the internship and the lobbying services will be unpaid. As a lobbyist, she represents that she will be appearing before the General Assembly, but she will not be appearing before her own agency, BHDDH, or the executive branch of government. She represents that upon completion of her studies, she will be returning to her state position, and at that time, her internship will be completed, and she will no longer lobby on behalf of the institute. Given this set of facts, she seeks guidance from the Ethics Commission regarding whether the Code of Ethics prohibits her from serving as a lobbyist on behalf of the institute during her internship. Here, based on all the representation of the petitioners, there is no indication that petitioners' unpaid service as a lobbyist on behalf of the institute would either impair her independence of judgment or create an interest in substantial conflict with duties as a social caseworker. Accordingly, it is the opinion of the staff that the Code of Ethics does not prohibit the petitioner from registering as a lobbyist on behalf of the institute during her internship with the institute. I'm happy to answer any questions you might have at this time. Thank
Ms.
you.
Gilbert, you've heard Ms. Papa's presentation. Do you have any questions or additional information?
No, she pretty much got it spot on.
Okay, thank you. Commissioners, does anybody have any questions or comments?
I'm sorry, I can't see Ms. Gilbert. Thank you.
My shortness.
Ms. Gilbert, that's part of your field placement, part of the master's degree
Yeah.
program?
Yeah.
And many years ago, I participated in it. When I was a state employee. Back then, your employer had close communication with wherever your field placement was, improved it in essence. Your employer has expressed no reservations whatsoever about the field placement. And
No, what happened was I had to ask, when I went to go register as a lobbyist, they said I should check with my supervisor. I went to the administrator, Kevin Savage. He then discussed it with the legal team and they recommended that I just run it by you all here at the Ethics Commission, just to make sure that I wasn't in any kind of violation.
And when you finish your master's degree, you're committed to continuing the employee of the state for a couple of years?
Absolutely.
Thank you.
Any other questions, comment? Commissioner Susie?
Do you have any specific items that you'll be lobbying for or against?
We have an agenda for the legislative season. So some of it might be revenue based on how we're gonna raise revenue in the state. It could be based on the paid leave act. That's one of the areas that they're involved in. So it could be a variety of different topics, but none of them will be directly related to DHDDH.
That's
If that's where you're going.
Any other questions or comments? Is there a motion to approve and issue the advisory opinion as presented by the staff? Motion by Commissioner Ritchie,
Second.
seconded by Commissioner Susie. Any further discussion? Roll call vote. Commissioner Susie,
Aye.
Commissioner Strauss. Aye. Commissioner Celerini,
Aye.
Peterson,
Aye.
Commissioner Rapidu.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you very much.
Thank you very much.
Appreciate it.
Have a great day.
The last advisory opinion on our calendar today is Lynn Underwood. Say. Sigley.
Yes, this is at tab A in your binder. Ms. Sigley had every intention to be here this morning. She sent me an email late last evening. Unfortunately, it's a medical emergency involving a family member this morning, and she apologizes but has asked that we continue in her absence. The petitioner is a member of the Newport City Council. She is currently the City Council's liaison to the Newport Tourism Marketing Management Authority, which is another municipal agency. The authority has an application pending before the City Council. Ms. Sigley seeks guidance regarding whether she is prohibited by the Code of Ethics from participating in City Council discussions and decision-making regarding the authority's application. Some pertinent factual background. In 2017, pursuant to the provisions of the District Management Authorities Act, enacted by the General Assembly in 2001, the City Council, assisted by Discover Newport, which is a local nonprofit dedicated to promoting tourism in Newport and surrounding East Bay communities, created the Newport Tourism Marketing Management District and Newport Tourism Marketing Management Authority. The district originally consisted of all lodging properties in Newport consisting of 20 rooms or more. It was established to exist for a 3-year period. The authority is tasked with stimulating tourism in the district. In 2021, the district was amended to include all the lodging properties in Newport consisting of 18 rooms or more. At that time, the district was also renewed for a second 3-year term. The authority is composed of about 20 members. These are representatives of the lodging properties that make up the district, plus 2 people from Discover Newport. The authority funds the stimulation of tourism in Newport by assessing and collecting a flat fee of $1.50 per room per night to be paid from the fees charged to guests by the lodging properties that make up the district. Again, the authority is a municipal agency. As the City Council's liaison to the authority, the petitioner attends meetings of the authority. She makes note at those meetings of the plans intended by the authority to promote tourism so that she can then inform the City Council about those plans. The petitioner will occasionally offer a suggestion to the authority, such as the one cited in the draft of having a jitney bus run from the train station in Kingston through Newport. The petitioner's role on the authority is limited to that of liaison. She is not a voting member of the authority. As I mentioned earlier, the district was renewed for a second 3-year period in 2021. It will expire this year unless it's renewed. The petitioner represents that the members of the authority have decided, rather than seek another 3-year renewal of the district, they will instead allow it to dissolve. When the terms of the district and the authority expire this year, so too shall the petitioner's role as the City Council's liaison to the authority. What the authority wishes to do is seek permission from the City Council to create a new tourism improvement district pursuant to a different act adopted by the General Assembly in 2022. called the Tourism Improvement Districts Act. Both the District Management Authorities Act and the Tourism Improvement Districts Act allow for the stimulation of tourism in Newport, funded in part by fees assessed from the nightly fees charged to guests in the lodging properties of the district. But the District Management Authorities Act has a 3-year term, applies only to certain municipalities, and its district was managed by an authority that was a municipal agency. The Tourism Improvement District Act has a 10-year term, applies to all municipalities, and will be managed by an owners association that is a private agency. Ms. Sigley will not be a member of the private owners association expected to manage the anticipated tourism improvement district. The authority's application seeking to create a tourism improvement district is pending before the city council now. It's actually expected to be heard tomorrow evening. The petitioner would like to participate in her role as a member of the city council. Under the Code of Ethics, the petitioner may not participate if she has reason to believe or expect that she, any person within her family, her business associate, or any business by which she is employed or which she represents will be directly financially impacted by reason of her official activity, nor may she participate in a matter when her business associate or a person authorized by her business associate appears or presents evidence or arguments before her municipal agency. The Ethics Commission has indicated that the Code of Ethics does not consider a public body to be a business, or the relationship between a public official and a public body to be that of business associates. Therefore, the Ethics Commission has in the past allowed public officials to participate in matters that would directly financially impact another public agency. There are several examples cited in the draft. Here, the authority for which the petitioner is the city council's liaison is a municipal agency, which is noted does not fit within the definition of business associate under the Code of Ethics. Further, even if the authority was a private organization, the petitioner's role as city council's liaison does not amount to a business association because the petitioner's non-voting liaison position affords her no ability to affect the authority's financial objectives. Accordingly, based on the petitioner's representations, consistent with the applicable provisions of the code and prior advisory opinions issued, it is the opinion of staff that the petitioner is not prohibited by the Code of Ethics from participating in city council discussions and decision-making relating to the application currently pending before the city council brought by the authority. I'm happy to answer any questions.
Thank you. Commissioners, anybody have any questions, comments? Hearing none. Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Rabideau. Is there a second?
Second. One second, I defer.
Second by Commissioner Susie. Any further discussion? Roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you.
Thank you.
Chair is going to take executive action, and we're going to skip to item number 7 on the agenda. In light of the light session and executive session, we'll hold it till the end. We're going to let Mr. Marion come forward with the common cause petition for adoption of or amendment of the rules and regulations. We began this discussion at the last meeting. First, to go with Commissioner Peterson and Commissioner Rabideau were absent for that meeting. So, Mr. Marion, you may wish to provide a more robust presentation to the entire commission.
You're on your agenda.
2 meetings ago?
2 meetings ago.
2 meetings ago? Were you here for that?
I wasn't here last meeting, actually.
Okay, so it was 2 meetings ago. That's good. So now you can't speak as. I tried. So then you missed the prior discussion. That's okay. He'll fill you in.
Good morning again. I'm John Marion. Thank you for taking me before the executive session. At January 7th, I presented a petition, that my organization sent to the commission back, I believe it was on December 17th. And that petition asked the commission to do three things. The first was to add lobbyists as a class to those whose gifts are limited by the gift rule. The second was to add a question to the financial disclosure form about gifts that are given, but for the fact that someone is a public official or employee. And the third is to examine the sections of law that the commission is charged with enforcing that touch on the awarding of contracts. The impetus for our petition in December was the investigation by the state police and the attorney general into the awarding of the contract to the ILO group. At that January meeting, I was asked to provide more information about that investigation and more evidence that the rule changes we propose are needed. So last week I sent you a letter, which is, I know, in your packet, that attempts to do those two things. So I'm going to briefly try to summarize the letter, but I won't read it. In approximately March of 2021, as he was assuming the governorship, Dan McKee and his administration put out a request for proposals for a consulting contract to reopen the schools that were closed by the pandemic. At the same time, a group called Chiefs for Change engaged a consulting firm to provide tens of thousands of dollars of consulting services to the McKee administration, completely free of charge to the state or to the governor. That firm is called SKDK. Right before the RFP for the reopening contract was issued, one of the leaders of Chiefs for Change created a new consulting firm called the ILO Group, which ended up bidding on the RFP. When a technical review committee reviewed the two bids they received, they recommended the other firm, not the ILO Group, that came in millions of dollars less than the ILO Group. The Governor McKee overrode that decision. Ultimately, the contract was awarded by a means other than an RFP. I think it was a master price agreement. And the ILO Group got the largest share of the business, but it was split between the two who had responded to the RFP. The state police and attorney general's investigation revealed that Chiefs for Change tried to evade the gift rule when they provided McKee with the tens of thousands of dollars in pre-consulting services from SKDK. The founder of the ILO Group, while still working at Chiefs for Change, actually rejected a first draft of the contract that was proposed by SKDK because it would, in our words, quote, look like a gift. I also want to mention that the only way we found out about this gift is the tens of thousands of dollars of free consulting services from SKDK was because of the criminal investigation. This has been in the news since since the summer of 2021, but none of the media reporting and all the many APRA requests that were part of that revealed this gift. So our first request is that the commission categorically include registered lobbyists into the definition of those whose gifts are limited by the Code of Ethics. We note that Chiefs for Change is a nonprofit organization, much like Common Cause, who I represent, and we might not fit the definition of an interested person. Lobbyists for nonprofit organizations are acting out of self-interest. When they give gifts to public officials, employees, they are lobbying, just like lobbyists for for-profit organizations and unions and other types of organizations. As I noted in our letter, 22 states specifically limit or ban gifts from lobbyists. And of those, 12 states also have broader limits, like Rhode Island currently does. So we would not be extraordinary if you took this step. So we think what we're asking for in the first part of our petition is both necessary based on the facts of the ILO Group investigation, and it's possible based on what we see in other states. The second part of our request is that you add a question to the financial disclosure form that would require the disclosure of gifts given, but for the fact that the person receiving the gift is a public official or employee. As we note in our letter, the code actually already requires disclosure of gifts that are greater than $100 in value. But currently those gifts, if they're from an interested person, are illegal. The code actually contains a requirement to disclose illegal gifts, which obviously isn't happening. Again, we turn to the ILO group investigation to justify our request. Governor McKee received tens of thousands of dollars for consulting services, and without the criminal investigation, we would never have known about it. Rhode Island should join, and this is a new statistic from our original petition, 28 states that require the disclosure of legal gifts given but for the fact that the person receiving the gift is a public official or employee. At your most recent meeting 2 weeks ago, you approved an advisory opinion for someone who accepted free travel that he received, but for the fact that he was a public employee. All you need to do is imagine that that advisory opinion request was for something that wasn't travel. And you look at the code of ethics, it wouldn't have been required to be disclosed, and he wouldn't have been before you. Finally, with respect to the third part of our request, a review of the procurement laws that you are charged with enforcing, we want to point out a comment made by our Attorney General, Peter Nerona, when he was announcing the results of this investigation. He noted that he was surprised to learn that Rhode Island was a state that did not have a law against so-called bid rigging. We were surprised as well at Common Cause. Our procurement process shouldn't be based on who you know. We think it's time to review that section of law and see if there are any ways it could be strengthened. So we would ask the commission to approve the petition for rulemaking and move the process forward so we could work with you on crafting rules. At this point, I'm happy to answer any questions about what I said or the letters I sent.
I'd first like to open the floor for questions to Mr. Merriman. Questions, concerns, rather than talking about your position or thoughts about the actual process.
As I understand it, you're requesting that we undertake a process to consider rulemaking so that lobbyists as a class, even though they may be non-interested within the definition of the code, if they give a gift to the public official, it must be reported by the public official, even though they have status as a non-interested party under the code.
Not quite. Thank you for the question. We are asking that lobbyists be included as a class in the gift rule for purposes of limiting the amount of a gift they can give. So right now, the gift rule limits the amount of a gift from an interested person, $25 and $75 aggregate over the course of a calendar year. We believe a lobbyist, particularly an organization like ours, which is a nonprofit and might not have a financial stake in the outcome of a decision that the public official is making, could give gifts in excess of that. I could give you a car, and you would pass judgment on something I'm asking you to do as a public official. My organization and me personally, we would not financially benefit because a change to the code of ethics is in the public interest. It's not in the private interest of Common Cause. We don't get more money because of it. But nonetheless, we think there's a conflict of interest because I, as a lobbyist, and lobbying you as a public official to take an action, and I shouldn't then also be allowed to give you gifts.
If I might, of course. I believe your earlier communications in writing and then your oral presentation have espoused that there should be a presumption that if you are a registered lobbyist, and even though you fall within the non-interested party exception, that gift should be reported by the public official, that there's a presumption to be created by a rule.
So again, we think any gift from anyone who's a registered lobbyist should be subject to the limits. But the second part is we think gifts from anyone, whether they're lobbyists or not, that are given, but for the fact that the person receiving the gift is subject to the code of ethics, that gift should be disclosed. So we're asking for two different things.
I'm sorry, maybe I'm having. Are you requesting that a presumption be established that lobbyists, registered lobbyists, if they give a gift, that although they are a non-interested party, that the gift creates a presumption of impropriety on the part of the public official? Yes or no? And then if you could explain.
You have the floor.
Yeah, so I'm aware, I'm not an attorney, I'm aware that the term presumption has a meaning. So I don't want to necessarily use that term. We are arguing that it is a conflict of interest for a lobbyist to be giving gifts to public officials. Full stop, right? That the only reason a lobbyist would be giving a gift to public officials is to try to influence them. And
what if they're relevant? What if they're close friends or?
there are exceptions in the gift rule. Well, first of all, the gift rule isn't a gift ban. Many states have gift bans, but we have a $25 limit. So I can buy you a cup of coffee before the Ethics Commission meeting, and we don't trip it. And I think that was done a couple of decades ago to prevent sort of ticky-tack complaints coming before you for people who aren't selling their public office because they got a cup of coffee. Significant gifts greater than $25. There are exceptions in the code. I'm not going to go through them all, but we think this exceptions are sufficiently sort of protective of that behavior. But there are several hundred registered lobbyists in the state. This isn't a huge class of people, but there are a class of people who, for the most part, are being paid, like myself, to try to influence government. And we, just like we think they're, they should have to register and report. We also think their gifts should be subject to these restrictions, whether or not that financial nexus exists. And, you had an advisory opinion today from somebody who wants to lobby on behalf of another nonprofit organization, the Economic Progress Institute. Whether the top marginal tax rate gets increased or not, the Economic Progress Institute does not financially benefit as an organization. But they're lobbying. And they're lobbyists, they're buying gifts. In all likelihood, they're trying to buy influence, not trying to besmirch them as an organization.
You're just asking to add lobbyist to the definition of C. That's it. Interested person and lobbyist for the gift rule. I know where you're trying to go, but I think he just wants to add lobbyist to the definition of interested person and lobbyist in section C right here to the gift rule. It's not a presumption of impropriety. It's just limited by the rule that already exists. Just and lobbyists are covered by this rule.
I'm getting a little befuddled, which probably is my normal course anyway. Are you suggesting now that any proposed rule only apply to nonprofits? Or,
No, I'm just saying nonprofits are likely the types of organizations that are gonna be captured by any change to the rule. Because if you're a for-profit corporation and you've hired a lobbyist, in all likelihood, you're lobbying on things that are going to economically benefit or hurt your corporation. So you're probably an interested person under the code. But if you're a nonprofit, you probably aren't going to financially benefit or be hurt by the action. But you still have lobbyists. And so we think those lobbyists and their gifts should be regulated by the commission.
Mr. Graham, I think you wanted to give us some help on this perhaps.
I did want to make one comment and clarification, and it's based on a bit of reporting from the last time this came up before the commission. And I don't recall which outfit it was that reported on it, but the way the article read was as if currently lobbyists aren't subject to the gift rule, and that what Common Cause is asking is that lobbyists be added, and that the commission was pushing back and was skeptical that lobbyists should be included in the gift reg. And I just want to clarify that most registered lobbyists in the state are already subject to the gift rule. They already are an interested person. So the lobbyist for CBS, the lobbyist for Council 94, they're an interested person because these lobbyists are representatives of a business or an organization that has a financial interest in the decisions that these legislators or public officials are already authorized to make. So it's inaccurate to say that lobbyists aren't currently subject to the gift rule. There are some lobbyists that might not be, like myself. I'm a government lobbyist, but you're a registered lobbyist. I'm registered with the Secretary of State. But I don't. But the Ethics Commission doesn't have a financial interest in whether or not the financial disclosure statute gets amended this year or not. So I wouldn't fall within the gift rule. Of course, I'm also not giving gifts, right? So government, there are many government lobbyists that are like me. And then there are also many nonprofit lobbyists like Mr. Marion, like our petitioner earlier today, who, while they're representing their nonprofit, the nonprofit doesn't fit within the definition of interested person. So lobbyists for businesses almost certainly are interested persons. They're subject to the gift rules, and they already know that. And public officials don't accept gifts. So I just want to clarify that for future reporting and for your benefit. And I guess I'll just leave it at that.
I guess I have a very good question. When we say public officials, all elected officials?
And
So.
yeah,
I guess let's-
anyone subject to the code.
Well, that's, I guess, let's take Ms. Gilbert. She's not here, but she becomes a lobbyist. Her best friend's on the school committee. She gives her a $250 gift. Is her best friend who's on the school committee subject to report that gift? Yes. So they don't know this.
Over $75.
What's that?
Be over $75.
Right, but they don't know this rule. So as we know, there are these people who watch over every public official in our communities. All of a sudden they get an ethics violation because she gave a gift to a friend who's not, she's a local official, who's not allowing it. It just, this might be a discussion for if we do rule it, but just that's what's going through my head right now is, we want to catch. But we want to make sure it envelops the bigger picture of lobbying at the state, but it also affects these small communities. Some towns that have planning board members or zoning board members who are elected, and it just gets a little tricky because you're friends.
Yeah, but if the gift is not given because of the office. If I give a Christmas present, it's not because he holds an office. The trigger here is that it's the intent of the gift. And if you look at the way the out-of-state travel is set up, it's out-of-state travel that you would not have got but for your position.
Okay. Well, that's
So-
actually not this.
No.
That's the second thing
Okay.
he's asking.
Okay. Yeah, sorry, you're right.
If hypothetically, if there's a registered lobbyist, and that person is attempting to lobby on behalf of a company to get a snow plowing contract on Block Island. If that registered lobbyist gives a gift to a childhood friend who happens to be a state official, but the state official doesn't know that that person's a lobbyist, are you getting to like strict liability? It may be, the phraseology of strict liability perhaps is not what I'm trying to get across.
Well, the violation has to be knowing or willful, so we don't have strict liability. Present.
Well, you know, as I understood the initial position, and perhaps the petitioner's position has evolved. I thought that the petitioner was coming in from the beginning. And to say, look, we're establishing lobbyists as a only reference category of employment within the code, because there's no other category of employment. But if you give a gift and you are somehow employed as a lobbyist, a registered lobbyist, that creates an obligation upon the public official to report if it's over the $25. I mean, as I said in the beginning, the public official is supposed to do. No, the 700 people who are registered lobbyists, even though they never appear before them, are trying to influence them. But that's my concern.
Yeah, sorry. And I think you're conflating the first two things we're asking. One is about applying as a class, obvious, the gift rule. The second is about disclosure of gifts that are only given but for the fact that the person is a public official. Those gifts presumably would be legal under the gift rule. So they might be from the gentleman from East Providence 2 weeks ago. You know, there was some conference he wanted to go to, you know, sponsored by an industry. The industry paid for him to go to that conference. There was no lobbyist involved there. It was just that the conference was paying for it. That, imagine it wasn't travel, that would have been disclosable under the second thing we're proposing. The first thing we're proposing is what Commissioner Peterson said, which is just essentially interested persons and lobbyists to the gift rule as it exists now. But the gift rule only applies if you're giving the gift to a person who's capable of making a decision that affects you as a lobbyist or your person employing you. So, as I understand it, you know, John Marion, you know, I could give the, you know, we'll stay with the Block Island example. I could give the, you know, town council chair of Block Island a gift, even if we've made this change, because like Common Cause isn't lobbying Block Island for anything. They're not considering anything that we're looking at. You know, I don't register to lobby Block Island for anything. It would apply to people I'm lobbying and make decisions that affect the issues I'm working on.
So I think the rule already kind of captures what you're getting at, but I would like a little bit more clarification on the second point, because I'm trying to understand whether I would agree with your second proposition.
So the second idea is that there are gifts being given that we don't know about. They aren't travel. We know about the out of state travel. But there are gifts being given to public officials only because they're public officials. So in the instance of the ILO group, McKee was given tens of thousands of dollars of pre-con consulting services by this communications firm, SKDK. The only reason we know about it is because the state police and the attorney general did a multi-year investigation. But we think it's in the public interest to kind of know who's giving gifts, or only for the fact that somebody is a public official.
So do you kind of, are you kind of saying that like, even if there's not a direct financial interest, it's kind of like maybe somebody gives a public official a gift with some expectation of a later benefit that might not be a direct current financial benefit?
Yeah, I mean, so in 2012, when we came with the proposal, for what became the travel rule, we accepted that, a lot of this travel that's being given, it's not from an interested person, but it might be from sort of an intermediary organization, like a nonprofit, that is sponsored by, people who are interested in the decisions that the public officials could make. So we wouldn't want to ban it, but we wanted to disclose it. And I'd argue it's been a helpful disclosure. Every year we see the media report on lots and lots of trips that public officials are taking on the dime of a variety of groups, some of which I would argue is more legitimate than others. Some of it is just veiled, washing, lobbying through a nonprofit. Other of it is just, truly educational.
So you're saying they could, you want the public official, this would be a rule that the public official would have to disclose a gift, not a prohibited one, but disclose a gift if what, just any gift, or is there a dollar figure?
So we would leave it to you. So again, going back to 2012, we came with a petition. We did not offer language. We left it to the commission to craft the language, and work with you to craft the language. You settled on out of state travel greater than $250 of value, and then a series, like basically a test that exists in the code for whether that travel needs to be disclosed. And so similarly, we would ask you to.
So you're identifying a hole, or you want to address the hole, which is really sort of nonprofit groups where someone could act through set up a nonprofit and or act through a nonprofit to wash lobbying.
So we think
That's
the
the hard
ILO
part.
investigation identified two possible.
Yeah.
Right? The one possible hole is that there's a class of people in organizations out there lobbying. They're nonprofits, but they want something from government. Common Cause, Chiefs for Change. These are all 501c3s and 501c4s that are employ lobbyists who want things from government. And those people, in many instances, can give gifts in excess of the $25. In this case, tens of thousands of dollars. The second thing is, the attorney general concluded that, he really couldn't determine if the gift was Dan McKee personally, or Governor Dan McKee and the McKee administration, or McKee for governor campaign. But we know, ultimately that gift was given. It was given to the McKee administration, but we didn't know that gift was given to the McKee administration. And we'd like to see some transparency around that.
But the Attorney General, and if you look at our rules, that was an exception. That if the gift is to the government or to the public official, to assist with constituent services or the functioning of government, that's allowed. That's allowed.
Right.
And if you put this in context, if you remember about the school opening, there were enough emergency orders there to wallpaper this room. And people were trying to get kids back to school. And the Attorney General said, as best I understand it, it wasn't a gift. He didn't make a definitive ruling that it was a gift to McKee, the governor, as an individual. But, and I think that with all due respect, sir, I think that your presentation, more or less creates that inference, that wasn't part of the Attorney General's report.
Yeah, I would just say, I think we tried to summarize, it was a 24-page report by the Attorney General. You know, ultimately, he concluded he couldn't prosecute it because it wasn't clear the gift to the person, what's the gift to the office, what's the gift to the campaign. I'm not inferring he did it, you know. Ultimately, we decided not to file a complaint with you because we didn't think anything could happen, but we think it identified these holes, so we come to you for rulemaking. And we do that, you know, my job is to give people, politicians, black eyes, right? My job is to try to put in place accountability laws for public officials. This could be any public official, you know, in any nonprofit. It just happens that these facts are, you know, I was asked to sort of explain why we think this rule is needed. We think the Island Group report shows why this was needed. There was specific discussion by the principals in this about how to shape, and the only word I can use is gift, because it was free services, so that it didn't trigger any gift or lobbying laws in Rhode Island.
May I ask you?
Sure.
I applaud your efforts. I've always applauded the efforts. I always agree, but I applaud you. I'm trying to formulate in my mind what this rule would encompass. First of all, drafting of this rule to recognize your concern. Do you have any language that we can sort of weigh and analyze, or is this something you're asking us to create?
So I'm asking you to create it because I think you're best positioned to come up with language that you could effectively enforce. So in 2012, what ultimately became the travel rule, we didn't come with specific language because we thought the commission through deliberation would come up with language that would work. I would say in the case of our first request, you know, what Commissioner Peterson has said, you know, quite simply, you know, adding and lobbyists is the sort of thing I would think we could do. I think that the second, adding the question of the financial disclosure would be a bigger challenge, but it would result in something like the current out-of-state travel rule. But we've only done this in my 16 years once, and that was what became the travel rule. And it worked well because we didn't come and say, here's our language, take it or leave it. And I've done that in regulatory environments before where we proposed the language, the rule, and said, we'd like you to adopt this rule. And I think the code is, you know, sufficiently nuanced that that approach doesn't necessarily work. I would be happy to present you with examples from other jurisdictions, though.
Let
Let me just respond to what you're saying, because I think there's a two-step process here. The first question is, are we going to engage in rulemaking? What we get provided with, if we choose to go into rulemaking, we might well ask for language at that point, if we decide to go that route. But right now, the only question before us is, are we going to engage in? And I don't think we should make it an assumption that it's a fait accompli that we would actually adopt a rule, even if we were to choose to engage in
I
rulemaking.
understand that clearly. I was just, in my mind, wondering if he had language that he feels would satisfy his concerns. And I could see, we enter into the rulemaking process. It's going to be a difficult task to capture exactly what he's trying to accomplish. Maybe nebulous, participatory, whatever. We'll leave it to trust and legal counsel to guide us in that direction. And I agree with you that insofar as the procedure is concerned, that is the way to go. However, I'm satisfied with his answer. He has no specific language, and I'll leave it.
Can I ask you a question? Do you think that this would, I know you're not gonna give, like, you don't wanna give language, but I'm just wondering if this would capture what you're trying to target. It says, interested person means a person or representative that has a direct financial interest or our prospective financial interest or, or an imminently, I don't know, an imminent financial interest, or basically you don't want somebody to give a gift and then a month later be like, hey, I'm presenting something before you. Remember that gift I gave you? Is that what you're trying to achieve?
No, actually not. We believe there are a group of individuals, organizations that don't have a financial interest in the decision that the public official is going to make, but they have an interest. Right? It's a common cause, doesn't have a financial interest in the vote you're about to take. But we're very interested. I'm up here lobbying for you to vote affirmatively. And that because of it, we're not going to have a financial interest ever. We're going to remain a nonprofit without a financial
If
interest.
the lobbyist, though, doesn't have financial, well, the lobbyist or whoever the lobbyist represents doesn't have a financial interest, then what's the problem, I guess?
Yeah, the problem is that the gift can be corrupting.
Okay.
So if I gave you a new car yesterday, and said, I'll see you tomorrow's meeting.
Right, might not necessarily be a financial interest, right?
Yeah,
But you got
and
it
vote
there.
for this petition,
Right.
There's still no financial interest on our part, the decision you're about to make. But if you were town council, I was the car dealer, and I was asking for you to approve a variance, there's the financial interest, and I give you the car.
Sure.
And
But wouldn't that already be covered?
yeah, that would be covered, but not if it's common cause. There's a whole class of organizations that we think aren't covered, who are out there actively, aggressively lobbying.
I just feel like if financial interest isn't necessary, basically kind of what you're saying, then why wouldn't like a gift from common cause be the same thing? That's what you're trying to target with lobbyists.
Yeah, so I'm saying a gift from common cause should be captured by
Okay.
rule, and it currently isn't.
Oh,
And in the ILO case, a
Got
gift
it.
from Chiefs for Change wouldn't have been captured because they're a nonprofit.
Maybe it's not financial, but the problem is that there were overlapping people involved. So it could be.
Could you please give us other examples, not including ILO, that we should consider in making a determination as to consider the rulemaking process? Now, you've been a lobbyist for many years. You participated in many meetings. Do you have examples of where there were problems that would fall within your proposed activities that we should consider?
Yeah, I mean, I can't say I have seen lobbyist X give lawmaker Y something greater than $25 in value. What I can say is I have had innumerable cups of coffee and lunches with, public officials in the state, and have never paid for any, like, for them in any instance, even though I think I could.
And you looking for permission to do
No,
something?
no. I've done that out of an abundance of caution, even though I've known that probably, if they came before you and asked for an advisory opinion, can I take a $50 dinner from John Marion? You would conclude that I'm not an interested person under the code of ethics. And all we're proposing is that I automatically be considered an interested person because I'm a registered lobbyist in the state of Rhode Island.
So again, all registered lobbyists should be considered interested persons.
Yes. Yeah,
That's the essential.
That's the first one.
That's the first line.
yeah,
Yeah, the first
yeah, and I realized my petition probably created confusion because I'm asking for multiple things. I think if I just come in and ask for the first thing.
What if it was just a direct interest and it wasn't a direct financial interest? Would that capture what you're trying to achieve?
Yeah, I honestly, I've never seen like a definition of a direct interest.
Cast a much wider net than
Right, no,
you're thinking, yeah. I mean, at least lobbyists is a very clear, distinct, identified group.
Yeah, and that's why I think you see around half the states sort of single out lobbyists. It is a pretty narrow category of people.
But isn't that primarily it isn't in the ethics. The ethics rules and regulations of that state. It's primarily in the legislative rules or.
It's in a mix of places. So as Jason said to you 2 weeks ago, it's very hard to do cross-state comparisons because you're the only ethics commission that has jurisdiction over all three branches, state and local, right? So in most states, there's a separate set of ethics laws that apply just to the legislature. Because of the change we made in 2016, have jurisdiction over the legislature, complete jurisdiction over the legislature. I think most of the examples we can think of involve the legislature, but not necessarily. But you could craft, I mean, you have rules that just apply to the legislature, right? There's a revolving door that just applies to the legislature. So you could craft it as you choose. And you could say this only applies to state officials, this only applies to executive branch officials, this only applies to the legislature. And you could exempt to Mr. or Commissioner Rebo's point, like local officials.
Have we barred two for a year from like seeking state appointment as being on the commission?
I'm a state employee.
Why not?
Yeah.
No, that just applies to state. And there's some restrictions also on major decision-making state employees, like chiefs of staff, elected officials have some limitations as to other state jobs that they can take, but not.
I guess my question is any of this already covered by the lobbying statute?
Yeah. Great.
The lobbying statutes are essentially about registration and disclosure. So I have to, register every year, and then I have to file reports on a monthly basis while the legislature's in session, and then on a quarterly basis after that. I have to report, and I'm trying to think because I don't, I report what bills I lobby on, which officials I lobby, but I never give anything, so I don't think. Yeah. I don't.
But if you did give, or even patronize the establishment of major decision makers, that's something that lobbyists.
Yeah, it's more than $250. If I went to a restaurant owned by a lawmaker, I spent more than $250. that wouldn't necessarily even be a gift. Yeah, and you have to report.
Yeah, I was just say, because it's also the other side, which is political contributions.
Yeah, which we haven't, we're not anything with respect
But if
to.
you went into a restaurant owned by a legislator.
Yep.
And you were in a group, so to speak. And the, maybe without food or drink, determine the dollar amount. You were in that group of individuals. All registered lobbyist like you, and that amount exceeded $25. Now, who reports? The legislator, annual, or which?
Well, so that is covered by an exception, which is I could, if a lawmaker owns a restaurant, I can go in and buy food at the restaurant. Like it's an arm's length transaction. This only applies to gifts where something's not given in return for what's given. So if I go into a restaurant owned by a lawmaker and I buy dinner, that's perfectly acceptable. And it would be perfectly acceptable under what we're proposing because it's an arm's length transaction.
Yeah.
It's not a gift.
You know, yeah.
Well, there would be.
Here's the situation that you're getting at, which is they go in, they sit down, they have a great meal, and the owner comes over and says, I'll comp you that.
Yeah.
Well, no, that's, fine. No, that's, all well and good, but I remember, Attorney General Eileen Barber, she first took office. She promulgated a rule in the Department of the Attorney General. None of her employees can go into certain establishments where had mafia connections or had, nefarious connections, so to speak. And that met with all kinds of resistance, so to speak, on this. Again, this goes back to the nebulous aspect of this, the anticipatory aspect of this. And as our chairperson stated, yeah, we can adopt, we can go into rulemaking process, but we're gonna come back to the same situation. We're gonna have to bring him in again, because we're not gonna be able to draft something and then ask him. He's gonna have to be part and parcel of our discussion, which we're doing here right now. So
Rulemaking itself is a process. So yeah, we might invite him to come back, but we might invite other people to come in too.
well,
To
yeah.
educate us on what it is that we're dealing with.
Well, I hear what you're saying, but again, so let's say we're able to craft some language, but that language is not satisfactory to common
bad.
cause. I understand. So he'd be spinning his wheels, which he doesn't want to do. And again, it's just a process to me. I wish he had language that we could look at and say, okay, makes sense, what doesn't make sense. But he's asking us to sit down and draft something that would satisfy common cause, but it may very well not be in everyone's best interest.
I don't hear it that way. I hear it as his raising an issue before us and asking us to study it and decide. If we decide to do rulemaking at all, to study it and decide if we can craft an appropriate rule to accomplish what we think needs to be accomplished.
Now,
Once it's in our hands, it's ours.
Okay, so in other words, what we think should be accomplished, notwithstanding what, we don't know exactly what he wants us to accomplish. So you're saying,
We have to understand what he's providing us.
Common cause identified a whole,
well,
which
the
is
whole,
that all squares are rectangles, not all rectangles are squares.
Yeah.
And so he wants us to fix the whole however we see fit. Maybe we decide there isn't a problem and do nothing after we go, but at least there's the exercise of exploring an issue.
Assuming that the commission votes to engage in rulemaking.
we're gonna have the same, okay, I anticipate we're gonna have the same problem amongst ourselves to try and come up with language that satisfies what fills what hole, but let it be.
If I might, if you can give me some guidance. You cite the ILO situation. In the ILO situation, Mr. McGee, the representative from Chiefs for Change, was not a registered lobbyist.
Correct.
So even if a lobbyist, according to was a suggestion of Commissioner Peterson, was in our rules and regulations, would it have addressed him?
So not presently, separately from this, we filed a complaint with the Secretary of State arguing that he should have been registered as a lobbyist and should retrospectively do that. And we have not heard from the Secretary of State about that complaint yet. If you read the Attorney General's report, he uses the verb lobbying, lobby, quite a bit as to what Mr. McGee, the head of Chiefs for Change, was doing with respect to the contract. I think it's, from our perspective, he was lobbying on behalf of his employer. He just wasn't registered to lobby. I didn't want to kind of complicate things because that's not before you. You're not the body that determines whether or not somebody is a lobbyist. That said, like, there are plenty of lobbyists and nonprofit organizations who register every year and lobby public officials like myself.
Are you saying that the Secretary of State fills that role?
The Secretary of State determines whether somebody should be registered as a lobbyist. You do not. That was power given to the Secretary under the.
So the Secretary of State defines who should be a lobbyist.
I mean, the statute does.
Well, exactly, but.
It's enforced by the Secretary.
So.
I mean, but that said, you've given lots of advisory opinions over the years where you try to determine if somebody is an interested person and you include in the analysis whether the person is a registered lobbyist. So you relied on that statutory definition and the enforcement of the Secretary of State for.
Do you know what that language
decades.
is? Do you have that language before you now?
I
That's okay, we
Yeah, I
can,
don't.
because that's interesting.
And I would just also point out, right, so you heard from your director 2 weeks ago, he gave ethics training, he was hearing from lawmakers that they would like to see the gift limit increase from $25. Like, if you need evidence that gifts are being given, it's lawmakers asking the commission to increase the amount that the gifts that can be given, right? So we know there are gifts being given, even if I can't come before you with concrete examples. Like they're asking you to increase the amount they can take from lobbyists.
That could well be because the price of a cup of coffee's gone so high.
Yeah.
The cup of coffee's now
It's all right.
$25 cup.
All right.
I mean, just see other reasons why they might come for us for that. I don't think we've spoken about procurement. So I'd like to get an idea of what it is that you think we can and should be doing in procurement, because I think we're entitled to enforce, but I don't know that we have any significant rulemaking for it.
Yeah, so the third request is simply that you look at the part of the statute that you're charged with enforcing, and which hasn't been amended since 1993, and is not part of the code of ethics that you've adopted, but was put in place by the legislature. And you decide whether or not that is still sufficient in 2025, sufficiently protective of the public interest. And you could, I think, choose two routes. If you don't think it is, you could say to the legislature, here's something we think you should change that statute. Or I believe you could include in the code of ethics language dealing with procurement, because procurement contracts are singled out in the state constitution with respect to your jurisdiction. It talks about financial disclosure, conflicts of interest, awarding of state contracts. And so I think, if you think you have the power, to make changes to the code based on that, language in the Constitution, that can include contracts. You know, I'll say we looked at the section you're charged with enforcing, and it's interesting, you know, I think the only time you've ever enforced it is in these Philadelphia cases that you've gone through one and you have another one before you. I'm not aware of another time that you've used that section. It's, you know, both sort of prospective and retrospective. It actually bars, gifts, or soliciting gifts if you're a public official, you know, if with somebody who might become a state contractor or has been a state contractor in the last 24 months. So it's a really interesting section of law. We don't have a hard ask, in part because my organization doesn't have a lot of expertise in procurement. It's a complicated area of law, but there are clearly some holes in it. Like there seems to be a part of the procurement law that you know, would prohibit sort of interference with the process that doesn't have a punishment. And then the Attorney General said in his public statements that I put in the letter, you know, apparently there are jurisdictions that have anti-bid rigging statutes. We're not one of them. I don't have any expertise on anti-bid rigging statutes.
You have a comment, Jason?
Yeah, just a couple comments on this part. So the talking about procurement. Third part. First, I just want to clarify that this statute is not part of the code of ethics. The code of ethics is 36, chapter 14, right? So when the General Assembly enacted this procurement statute that we're talking about, they didn't put it in chapter 14. They created a new chapter called chapter 14.1. So it's not a part of the code of ethics. We don't. So I just want to be clear about that. They just gave the Ethics Commission the enforcement authority, which is a nice thing, you know. We're already set up to enforce certain things, so they just said, well, let's give it to the Ethics Commission. I just want to I want to note that, you know, procurement is a big area, right, that is generally regulated by statute. There are procurement laws in the state that aren't part of the code of ethics, but there's a scheme of regulating procurements in state statute. And also there's an entire division of the Department of Administration, the Division of Purchases, that has regulatory authority over procurement and purchases. They have rulemaking authority. They can enact, the Department of Administrations can adopt regulations relative to procurement. And, you know, I think that the commission would want to be very careful about how far we expand our jurisdiction into being the state's procurement commission. We do have constitutional authority over contracts, and there is a part of the code of ethics that deals with contracts. It's 3614.5H of the code of ethics, which has very specific requirements for people subject to the code who want to enter into contracts with the state or with cities and towns. These contracts have to be public bid type contracts with public knowledge before the fact and after the fact of everything. So I just want to kind of provide that kind of background about contracts.
And let's not forget that there's that office called the Office of the Attorney General, which has its own involvement in bid rigging and bad behavior in bid context if it's criminal. So,
Well, not only that, but the Attorney General also has the authority to enforce the provisions of the procurement statute. So our jurisdiction is non-exclusive. And I think if we're asked to adopt or issue a regulation that relates to the procurement statute, which is outside the code of ethics, I think anyone charged with that would certainly challenge So I think it's very unclear as to whether or not we have the authority to adopt a regulation relative to the procurement statute.
Appreciate that. Any further discussion on any of these issues at the moment? I think I'm gonna break them down into the three issues. And I wanna know, based on our discussion, is there a motion to initiate rulemaking as to the gift rule, Commission Regulation 1.4.2? Is there a motion? Is there a motion to deny the petition of common cause to initiate rulemaking as to the gift rule, Commission Regulation 1.4.2, as the petitioner has not demonstrated a need for amending the regulation?
So moved.
There a second?
Second.
Motion by Commissioner Santorini, seconded by Commissioner Susie. Any further discussion? Roll call vote, Commissioner Susie,
Aye.
Commissioner Strauss,
Aye.
Commissioner Santorini,
Aye.
Commissioner Peterson,
Nay.
Commissioner Rabidou,
Nay.
Commissioner Ritchie.
Nay.
Oh, joy. Chair is conflicted. Abstained. No, sorry. I have to vote nay as well. So we have no motion to initiate rulemaking and we have no motion or no past motion to deny. I think that has to mean that it's effectively denied. Am I not right?
Well, you're going very fast, so I will make a motion to initiate rulemaking.
I'm sorry, I didn't mean,
That's okay, we just.
I thought I made the
was thinking-
motion.
You did, well, you said asked, and then you went quickly into, is there a motion against, and I just didn't get a chance to pipe up.
I had a motion to initiate was the first motion.
You did, I know, and then no one said anything, and I was thinking about it, and then you rolled into, is there a motion to
Well,
deny?
I'm sorry, I thought I had waited long enough for a motion. to be made.
I would like to reconsider if there's still an opportunity to make a motion.
Okay, in that case, I'll reopen that. I don't think anybody would object to that. If there's a motion to go another direction, I'd like to hear it.
I'd like what you first said, motion to initiate rulemaking on the gift payment.
So there's a motion made to initiate rulemaking as to the gift rule, Commission Regulation 1.4.2. Is there a second?
I'll second it.
Motion by Commissioner Peterson, seconded by Commissioner Rabidou. Any further discussion? Roll call vote, Commissioner Susie,
No.
Commissioner Strauss,
I realize I'm flipping my vote, but I'll say aye. Man, I didn't see any harm.
Commissioner Santorini, Commissioner Peterson,
Aye.
Commissioner Rabidou,
Aye.
Commissioner Ritchie,
To be consistent, aye.
and the chair votes aye. So the decision will be that we will engage in rulemaking with respect to the gift rule, Commission Regulation 1.4.2.
When I said to be consistent, I meant, my whole purpose was to have to sit down and see if we can formulate something. That's why in the first round, nay, because that would be quality. That's right. I see our trusted council saying, what, that's where.
No,
it's-
we're gonna have that too. because
Precisely.
We're gonna have rulemaking. It's gonna
It
be
was
a-
my failure
No,
not to wait long enough for the motion.
That's good, it's all clear.
It's all on the table.
all clear.
All right, now. Is there a motion to initiate rulemaking as to the financial disclosure form?
I'm not making a motion.
Look around the room. Hearing no motion to initiate rulemaking, is there a motion to deny the petition of Common Cause Rhode Island to initiate rulemaking as to the financial disclosure form, as the petitioner has not demonstrated a need for amending the form or adopting or amending the financial disclosure regulations?
Well, okay, so if you hadn't put that language in now, it's a motion to approve it, then I would vote yes. You didn't say that, so all due respect.
Well, there's a different standard.
Well, but there is, by the same token, that's, I think, caused the confusion the last time. So let's go back to Mr. Council.
There's no motion pending of any kind at the moment, correct? No motion
Nothing's
pending.
pending.
All right.
You can make a
So,
motion.
so make the motion you'd like to
Well,
make.
regarding financial disclosure, I think that's, if I understand correctly, that is to consider whether we should raise the limit.
No.
No.
Okay, nothing in
No.
the gift at all, nothing in
No.
the law. So what does that? do, Mr.
Financial disclosure.
To add
That's-
the question,
To add the question.
to add the question.
That goes back to the, who's a lobbyist and whether that
No,
lobbyist
it's
should.
a kind of question, if you get a gift, but for the fact you are a, subject to the code. You disclose any gifts that you get.
Yeah.
Just,
But subject, for someone who is a registered lobbyist, but who ain't,
No, Anybody,
anybody.
anybody,
and
anybody.
I understand.
So I'll start again, just so we're clear. Is there a motion to initiate rulemaking as to the financial disclosure form?
Regarding what's up? All of it? The whole form?
Well, it's as to the form based on the petition.
Right.
But that's the motion is, are we going to get engaged in rulemaking to modify the financial disclosure form? Broadly speaking, but where focus is on this,
As suggested by Common Cause.
right, as petition.
I can summarize it in, just to make sure everyone
Yeah.
knows what it is.
Fine.
It's to add disclosure of gifts over $25 that the official would not have received but for their public
So
disclosure.
I understand.
With that understanding is,
But is it solely related that the gift originates from a lobbyist?
I think that's good.
Part, the second proposal.
That was my concern.
There's the first proposal, which is adding lobbyists to the gift rule that exists,
that's
which we motioned on.
Right.
The second petition is to add to the financial disclosure form, any gift that you get over $25. But for the fact you got the gift because you are such.
Here's what, maybe this will help. Is there, perhaps the question should be, is there a motion to initiate rulemaking as to the financial disclosure form to add a question requiring the disclosure of gifts if under the totality of the circumstances, it is more likely than not that the person or entity would not have given the gifts but for the officials or public employees, public office.
Could I give a point of information? In times past, the contents of the financial disclosure, were they established by rule?
The contents of the financial disclosure were initially established by statutes set by the General Assembly. In years since, the commission has amended its regulations to clarify those disclosures, to expand upon those disclosures, and in some cases, such as the travel disclosure, to add an entirely new disclosure to the financial disclosure statement. So the things that you put on your financial disclosure statement, there are, I think, 16 questions. A majority of those came from statute. The General Assembly said, we want this information on your form. And a couple of those questions came from the Ethics Commission saying, in addition to those, we want to see a couple extra things on
through our rulemaking.
through.
That's what I was gonna ask.
So the questions just can't be prepared by the staff. There has to be a rule that permits the staff to put the question in the.
So has that been moved and seconded? So we had discussion or we're not?
There's no
We haven't, there's no motion on the table yet.
I'll just say it
Please,
again.
I'm gonna ask council to repeat the question, so we're all on the same page here.
So perhaps the motion should be to initiate rulemaking as to financial disclosure form, to add a question to the form, specifically a question that requires the disclosure of gifts if under the totality of the circumstances, it is more likely than not that the person or entity would not have given the gifts but for the officials or employees' public office or position.
Very specific question. Is there such a motion? In that case, is there a motion to deny the petition of common cause to initiate rulemaking as to the financial disclosure form? The language, to add, to add a question regarding disclosure of gifts where the totality of circumstances suggests that it was more likely than not that the gift was given because of your office. Is there a motion to deny the petition of common cause because common cause has not demonstrated a need for amending the form or adopting or amending the financial disclosure regulation?
I'll move that.
Motion by Commissioner Rabideau to deny the petition. Is there a second?
Second.
Second by Commissioner Centarini. Roll call.
Is there discussion?
Is there discussion? Thank you.
I mean, making a lot of business for lawyers. I mean, could you imagine somebody who's on a school committee or whatever, the totality of the circumstances, trying to figure out what all of that means? I mean, they spent a lot of time in law school. You know,
We have a similar regulation for out-of-state travel. That's the same set of factors that go into out-of-state travel and whether you have to report it. I agree that it puts the onus on the reporter to decide, would it have been given to me because, or wouldn't have been given to me because, and that's a potential risk edge that we might not want to create, but it already exists.
but out-of-state travel was a more concrete, distinct entity than a gift from somebody you went to high school with.
Understood. Any other discussion? So the vote, take a roll call vote to deny petition. Commissioner Susie,
Aye.
Commissioner Strauss. Commissioner Centarini.
This is to deny,
To
right?
deny.
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Now, the third question, and again, I'll start from the positive side. Is there a motion to initiate rulemaking as to procurement? And Commissioner Ritchie, yes, it's a very broad motion because we're being asked to look at it as a whole, not a specific provision, just as a whole. I think that's correct. Correct?
Could I interject?
Please.
I'm not certain that as to number 3, it's a petition for rulemaking. Because.
That's what we have before us.
Yeah, I would have to go back to look at the original letter, but essentially,
I thought it was on number 3, you were asking us to just to study it and maybe offer some recommendations to the General Assembly.
Should examine
that
the
was my,
section.
I'm not certain that number 3 belongs in the petition for rulemaking.
Actually, the original letter reads, in light of recent events, we believe the commission should examine the section of the code that applies to procurement. While we have no specific recommendations at this time with respect to General Law, Section 36-14.1-1 at SEEK, this section of the code has not been amended since 1993. We hope that a review of best practices from other jurisdictions will reveal policies that better protect the procurement process from political interference. That being the case,
And also,
well,
could I just point
yes.
out, in that original letter, with respect to the first point, we specifically say rulemaking. Second point, we specifically say rulemaking. And the third, we just use the word examine. I don't consider that part of the petition for rulemaking as under the APA.
What are you asking us to do?
I mean, you could, in the same way, 2 weeks ago, you directed the director to put on the agenda and do some research about raising the gift limit. You could direct the staff to come back to you with some research
I
about
think
procurement.
the director's comments satisfies me individually. I don't see any need to even discuss this.
We're gonna have a discussion.
Well, I mean, he says examination, so we can.
Oh, you mean discussing the issue?
Yeah.
That's a whole.
Yeah, well, again, I think
So I
it's
guess,
not before us. I mean,
well, my question is then, if this is not part of the petition, then we don't have to vote on whether we're gonna do rulemaking.
so,
So is there anything before us that we would be sending, I mean, do we have to make a motion to send them off to look at the other information?
I don't think so.
Or we simply ask them to come back and that staff come
Just
back
leave
and
it
tell us?
I think you could, if the staff is going to come back at some point in time relative to increasing the gift amount $25, at the same time, they could come back with some.
But do we have to make a motion?
I don't think you.
I would say that unless you direct me to task my staff with beginning a research project on procurement laws and such, I'm not going to do that.
Then let me try it this way. Is there a motion for the Ethics Commission to begin to study the issue of procurement for purposes of either later rulemaking or for purposes of later suggestion of the General Assembly for change to statute? There being no interest, I don't think we have to do any more than that at the moment.
You don't.
Unless I'm mistaken, I think that finishes this agenda item. Thank you, Mr. Marion. We appreciate your time too. That takes us now, I believe, with everything except, first we go to, it's a motion to go into executive session to wit, to approve, a motion to approve minutes of the executive session held on January 28th, 2025, pursuant to RI Gen Law Section 42-46-5A2 and 4, and then a motion to return to open session. Is there such a motion?
So moved.
Seconded by. Motion by Commissioner Peterson, seconded by Commissioner Ritchie. Roll call vote, Commissioner Susan. Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. And the chair votes aye. We'll now go into executive session.
This will only take a couple of minutes and then we'll be back in open session just to finish up the meeting.